This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.
Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. Do you know of someone who is involved in what seems to be a never-ending divorce? Why is it so difficult for some couples to sever the matrimonial bonds? Today we'll talk to the Honorable Jacqueline Silberman, Supreme Court Justice and Administrative Judge for Matrimonial Matters. And we'll see what she is doing to reduce the current backlog of matrimonial cases. We'll also talk to Stephen Gassman, a matrimonial attorney, and hear his point of view on this. Steve is a member of the Matrimonial Committee. Hello, Judge Silberman. Hello, Steve Gassman. Stephen? Thank you both for once more appearing on Lawline. Judge Silberman, tell me, what is the status of cases that we understand take 2, 3, 4, and in some years more than 5 years to reach its fruition?
Unfortunately, even 5 years is not the longest time known. Part of the problem was the courts. And the court bears some of the responsibility in the sense that the way we handled them in the past, letting them be in calendars with other types of cases, jury cases, and they were sort of put to the bottom of the stack. Part of the problem are the couples themselves, the litigants, who somehow or other can't cut the umbilical cord or can't stop the tango they're in. They need that tie of the marriage, and they're not ready to break it.
They still want that relationship to continue.
They still want that relationship, even if it's a fighting one. They still need something about it. And of course, some of the problem is the attorneys in the cases who are churning these matters and not handling them properly and not bringing them to a resolution.
Steve, who wins in these long, drawn-out cases?
Unfortunately, in the real long cases, usually nobody. Because what's happened is people are so worn, their resources are so exhausted, and it's not just attorneys, it's appraisers, it's accountants, it's court services, and everyone else. And it goes on for so long, they really both lose. And if they really look in retrospect and said, had we been reasonable at the very outset, this would have been much better for both of us.
I appreciate what you're saying. However, isn't there usually one party who is really dragging it out?
Well, there is. Sometimes that's because of economic advantage, because the party doesn't want to part with his or her assets, or another party doesn't want to give the other spouse their, quote, freedom to remarry or what have you. And you have those elements. This is a very personal, emotion-wrenching process, and we have to realize that. And so you do have that. And part of the fault for the long delays, if you will, is with the litigants.
Judge, what are the courts doing now to saying, hey, stop it? I'm giving you this amount of time to complete discovery, and we're having a trial whether you're ready or not. Is that what the courts are doing?
The courts are doing a lot of that. Chief Judge Judith Kaye is committed to this area of the law, and in 1993 enacted what are the old rules now, but are fondly referred to as the new matrimonial rules, in November 1993, which gives us a timeline in which these cases must be handled. And even in complex cases, that timeline is a year from start to finish.
Well, certainly a year. In other words, if a case comes in today, and I guess if they file...
That's a complex case. It should be much shorter in a less complex case. When they file, that case should be before a judge now in 45 days at no longer than that. That's a maximum. The case must be before a judge.
Now, those are new cases coming into the court system.
That's correct.
Statewide.
That is
so
correct.
Anybody watching this show, if they're on the verge of a matrimonial matter, they can be assured from the court system that they're going to endeavor and try to have that matter concluded within 12 months?
That's exactly right. That is the time frame in which these cases should be completed, at least.
And what about, Steve, what about cases that have been hanging around for years already?
Well, that's the backlog that Justice Silverman really has been working on to try to get rid of these cases, because they've been hanging around sometimes 5 years or longer, as was said. But there's a finite amount of those cases. The new cases coming into the system will have a definite period, and it'll be much shorter.
Steve, how do you answer the criticism that the lawyer is responsible, in part, for dragging out these cases?
Well, usually that's where the blame is put, and I don't think it's put fairly in most cases, and some that it is fair, there's no question. But you must understand that not every litigant in a matrimonial wants their case concluded in 6 months or a year. We're bringing cases into the system, we're saying we're going to rush them because it's beneficial for the system to remove this case from it in 6 months to a year. But emotional wounds haven't healed. Not everyone wants to proceed at that pace. So we have to push people, if you will, to say, the system says we must move expeditiously, you're going to have to get on with your life, like it or not.
But in those cases where the parties aren't ready and the attorneys recognize them, they can file the certificate of no necessity, and many attorneys aren't doing that. And they are in that period of what we call healing. There are attorneys, you will admit, that are churning these files and not just letting the parties heal and not billing for time doing I don't know what.
Well, my experience, Judge, is that almost in every case, the attorneys will want to settle the case. And very often at an early stage of the case, the two attorneys will reach an agreement that is fair and equitable. But they can't get their clients very often, sometimes for bona fide reasons, to agree. A year or two later, mystically, that same settlement appears, and then it's finalized.
I used to feel that a matrimonial case needed time to ripen, time to heal. But I found, in my experience, and now I've been sitting in matrimonial parts for 10 years, that those cases come in with attorney's fees that have built up, with unrealistic expectations that have been sold by various attorneys, and that those cases are no more ready to settle sometimes when they come in 2 years later than they would have been if they came in 6 months. Now, that's not with an attorney necessarily such as yourself, but so many of the others.
But Judge, you hit on a very keen phrase there, unrealistic expectations. That's probably the single greatest cause for delay in these cases. That someone has been fed a line, if you will, that he or she is going to get out of this with a deal that is totally unrealistic.
Let's talk about that, because that's what really people want to hear. If they're sitting in their living rooms, they want to know, what can I expect? If I am the breadwinner, what can I expect? If I work in the home, what can I expect? The marriage of long duration is breaking up. I could go to one lawyer and he'll tell me I'm going to get thousands, tens of thousands, and that may not be realistic, and it may result in huge legal fees. Judge, are there guidelines that people should know about?
It's hard to put guidelines because each case is fact-specific, but I have seen attorneys telling women who have been homemakers, who are young women, I'm talking about women sometimes 35, 40 years old, that they can expect lifetime maintenance in the case, and that they should not go out to work during the period of the matrimonial proceeding. And these women don't. They get more depressed and more involved in the process, more litigious, and really that is an unrealistic expectation in most cases, that they would have been better off if they were told to try to get some sort of job, show the court that they are working. Other things they're told, sometimes there is separate property issues, and they're told, well, we'll prove an increase in value, and they're not told how much it will cost for the experts to trace the values of this property.
Which might be
and they're not told that what they may get at the end is maybe half of, let's say they'll prove $100,000 is $50,000, but the cost to get there may be $200,000 along the way. And those are the things that are not explained. Yes, you have a right to the increased value of separate property, but if we're not talking about money that is hundreds and hundreds of thousands, the cost of tracing it, the costs of proving it in court are just not worth it.
Steve, are there any guidelines that you give clients if 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 the wage earner earns a certain level, you'll get X percentage of the,
Well, we
of the
have,
earnings.
Alan, a mandatory child support
Let's hear
guideline
about
law in the state.
Okay.
Which, if there's one child, it's based on a mandatory basis to $80,000 of income, but commonly being applied to amounts above that. Whereas if there's one child, is 17% of the combined parental income, gross income. we're talking
Combined
about.
parental
Right.
income.
2 children, 25%, 3,
Now, that's
29,
just
and
for-
so forth.
well,
That's for child support.
that's for child support.
Yes.
Okay, but now let's assume I worked in the home for 18 years, I raised 3 kids, I haven't worked in 18
And
years.
if you've been out of the marketplace and your greatest earning years are behind you rather than ahead of you,
Right.
courts generally are going to award maintenance for some protracted period of time.
What can I expect? Is there a percentage?
If it's a 45, 50-year-old person who's never really worked, all their years have been put as a homemaker, rearing
Right.
the children, etc., there's a trend towards what we call indefinite alimony or maintenance, meaning until death or remarriage.
Is there a percentage, Steve? What can I expect?
You generally have to figure between the child support and the alimony, the maintenance, you're going to run in that area of a third to a half of the breadwinner's income,
Gross income, net income?
gross income, and maximum. There are people who have this unrealistic expectation that between the two, I'm going to get 60, 70% of gross. It doesn't work that way. Rarely.
But when you use the term gross income, if man earns $100,000 a year gross, that's what it says, and that's what he gets, and that's what he pays taxes on. Of course, he doesn't bring that home.
That's
He may
correct.
bring home $65,000 after taxes, but they can award up to 50% of the gross.
Well, you have child support alone. If that individual has 3 children, 29% of gross is going to child support alone.
Okay, and then the balance, or the 20%, could very well go for
right.
maintenance.
But understand that the judge will include into calculations what the non-breadwinning spouse may receive as interest income off the equitable distribution,
Right.
to give what she will be having for herself and her children for running that household, and looking at the cash flow that way as well.
Judge, and what about the case, again, the same scenario, but no children? The children are out of the house. The children are married. They're have wonderful families, and they're self-supporting. But I'm in a marriage of 25 years. I've never worked. I've taken care of the home. I've taken care of the breadwinner. What can I expect?
You can expect lifetime maintenance to keep you in the style to which you have become accustomed during the marriage. But taking into account, of course, the interest you will be earning off your equitable distribution will
And you can
play into
expect
it.
50% of the value of the assets acquired during the marriage.
Because it's long-term.
Exactly.
Absolutely.
50%. It's even, Stephen, half and half.
We're moving closer towards that community property concept.
Okay, what if we're only married 5 years, Judge?
I believe marriage is an economic partnership. In the 5 years, you will have put together a smaller amount of marital property, and the percentage should not necessarily be affected at all.
But Steve, what happens if the earner put in a lot of money into the marriage, because it's a marriage where we got married late in life? We were both in our 50s or our late 40s, and he brought in a lot of money. I didn't bring in that much. But can I get that money he brought
Yeah, the
in?
law recognized that in terms of separate property credits, if you will. You used your money from prior to the marriage, your separate property, to acquire these marital assets, and the law gives you a credit in most cases for that.
I mean, a credit to the person who brings the money
Exactly,
in.
exactly.
So that's not divided.
Correct. That aspect of it is not.
Provided you don't commingle it,
Right.
and provided it's not an active asset like a business, which then increases in value during the course of the marriage.
Commingle is a legal phrase, Your Honor.
Okay.
What do we mean? Because everybody wants to know
Put
their
in
rights.
Joint names. That's
Do
what-
not put it in joint names. Do not even put it into the bank account you may have in your own name, which is marital funds, which may be, for example, if you're also work and you have your own account and you put in your working money into that account, now you inherit money and you put it into the same account. We don't know, since money is fungible, money all looks alike, so when you spend money, you can't say that the money I'm spending is the money I earned, not my inherited money.
Keep your money from prior separate.
Keep it separate, in a separate account, separate brokerage account, if it's a brokerage account.
And bear in mind, Alan, especially in your hypothetical where you're talking about people who are married a little later in life, more and more, these matters are being taken care of by prenuptial agreements, which are becoming much more common.
I could appreciate that, but you know, we're in love. And I really don't want to upset the apple cart. I love this woman, and I really feel a little awkward. Maybe I've made some money in my life, and she's maybe not at my level. But I feel awkward telling her to get a lawyer to meet my lawyer, and it's a little inconsistent.
Well, it's the antithesis of what you're doing. You're supposedly getting married, for better, for worse, and forever. And now you're saying, let's plan on what happens if it doesn't work.
That's right.
So it's difficult.
And I have to negotiate with you because I want to keep my money.
Exactly. And sometimes it breaks up the contemplated marriage. But at the very least, heed the judge's admonition of keeping it separate and not commingling it with the other parties.
But you as a
accounts.
lawyer, when you sit down on these contractual agreements before the couple is married, how do you get over that?
It's become easier because it's much more commonplace and people expect it more. They realize it's not the bizarre situation. This is becoming the norm. We see it more and more. So it's becoming a little easier.
Look in Louisiana, they even put
right.
for that thing where it's before marriage, first marriages, sometimes with young people, they can elect whether to have a covenant marriage or a non-covenant marriage.
I don't even know what that means.
Well, it makes it a little more difficult to get a divorce. That's the bottom line.
Is that right?
A covenant marriage means that you only can get divorced with grounds.
I see. Judge, let's take a little more practical. Again, a late marriage. I own my own home. I have my own co-op. I have my own condo. The spouse comes to live in my condo, my home, my co-op. We live there 5 years and it doesn't work out. Will she get half my co-op?
No, she will not get half of your co-op, and we can assume that unless there were changes made in the co-op,
So it stays mine.
it would stay yours, unless, for example, she redecorated and changed bathrooms and put in a sauna or something that material increased the price, then that increase in value of the co-op is no longer due to market forces, maybe due to something she did, in which case she'd share in that increase in value.
We have to take a break now, but that certainly sounded like good advice. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us.
Why would anybody give someone they don't know a gift? They do it because this gift saves lives. And the need for it is desperate. We need over 20,000 people to give this precious gift every day. Please give blood. There's a life to be saved right now. Call the American Red Cross at 1-800-GIVE-LIFE.
Hello. You're watching Lawline. I'm Alan Schnorman, your host. We're talking about how to speed up divorces and basically the rights of parties to a divorce. We're honored to have Judge Jacqueline Silberman. Judge Silberman is head of the Matrimonial Matters statewide. Chief Administrative Judge on that respect, and Stephen Gassman, a noted matrimonial attorney. Steve, now, if someone owns a business, the value of a business, the parties are breaking up, and let's say I'm the non-working spouse, okay? I want a part of that business. I know the business has been in your family 30 years, but I've been in your life 20 years. How much am I going to get of your business?
You're going to get a sizable percentage of that business, Alan, because the law recognizes that, A, if it was acquired during the marriage, it's marital property, and even though I, as the spouse, may not have worked in that business, if I made other contributions to the marriage, I'm going to get my share, fair share, up to 50% usually, of the value of that business at the time the divorce action is commenced.
But the husband had the business for 10 years before he even met her.
So what we do then is we value the business at the time of marriage and at the time of the divorce. The difference, because it's what's called an active asset, was worked on every day, is the appreciation in his separate property. That is deemed marital property, which is divided between the husband and wife.
Judge, even lawyers get divorced, I understand.
Yes.
On occasion.
Even judges in some cases. But even lawyers. However, let me ask you this. How is a practice evaluated? And the non-lawyer says, I want an interest in that practice. Does the non-lawyer have a right to a lawyer's practice?
Yes, and to a doctor's practice. All of these things can be valued, and there is this whole cottage industry, as the Wall Street Journal and the New York Times indicated, that has grown up around matrimonial cases and valuing these very things, these very businesses, these very practices, and that is subject all to its own, and is very costly, very time-consuming, but the hardest part of matrimonial practice. And one of the things I must say about good matrimonial lawyers is they are very fine commercial lawyers, because what they are doing is valuing assets and telling clients of the tax consequences of various deals. So they are very good commercial lawyers.
Steve, how long have we had equitable distribution in the state?
Well, it's 17 years now, Alan. We adopted equitable distribution in 1980, in July of 1980.
Okay. Now, I've heard mixed review. What's your opinion on it?
I think equitable distribution is a very fair law when properly applied. The problem with equitable distribution is it's cumbersome, it's expensive. And we have to overcome that. That's why, through Judge Silberman's committee that we're working on, we're trying to streamline this process a little bit. The criticism with matrimonial cases is that they took too long and they cost too much. That was a valid criticism on both points. We're trying to streamline this to make it quicker, to make it less expensive.
Steve, my viewers are always concerned with dollars and cents. If they're a substantial couple and it's breaking up and they've been a marriage of long duration, what are they talking about? How much does a matrimonial matter
Well,
run?
if you're talking about, when you say substantial couple, you mean someone
he's
who...
professional, he's got a business, you know, their assets accumulated, they have a house, they may have two homes, one in
The attorney's fees can go anywhere from $25,000 to $100,000 and up, and we've all seen examples of it.
We've seen in the and up from
Yes.
$500,000 and up on each side of the
in
case.
legal
You talk
fees?
about
For
these
one
large
party.
cases, yes.
And expert fees of upwards of $100,000.
Now, tell me, what is your committee, Judge, trying to do to stop, at least cut this down to something that is reasonable?
Well, we're trying to cut the timelines. We're trying to encourage the appointment of neutral evaluators rather than having each side hire his or her own experts and have the appointment of neutral evaluators.
Court evaluator?
As it were.
Something similar to a custody matter where the
Well, it
court
wouldn't be
appoints a particular person to advise the court on...
Exactly,
the status of
and
the
that
parties.
helps streamline the process in several ways. One, it gives us one expert at the trial, generally speaking. Two, it helps us on discovery, which is this getting of the documents in order to get the appraisal. And because if the court appoints an appraiser or an expert, as it were, the expert will then tell the court what materials it needs in order to do the appraiser's job, and the court will then order the parties to produce those documents.
How do you feel about that, Steve?
I'm in favor of it, Alan, and globally there's something that's more important that's happening. For years and years, matrimonial lawyers issued the hue and cry where our cases are the stepchild of the courts. We were not given priority. The accident cases, the commercial cases, were in our judgment.
Right.
That has changed, and no small part to this committee, to Chief Judge Kaye, to Judge Silberman. Now, the courts are saying, we're giving a priority to these cases which involve a dissolution of a family. This is something that society has to give a priority to. And you're seeing that in courts throughout the state. 5 years ago, 10 years ago, you did not see that. And that's really a revolutionary change.
Judge, what's your advice? If you had the legislature sitting out there, if you had state senators and state assemblymen and the governor, do you have any suggestions on how to enhance the matrimonial laws on the books today to make them better?
I don't think what we really need so much is legislative change. I think the change has to come from within the system, to some extent from the judges that are in the system. Hopefully that we will have more people in the system who care about this area of the law and want to give it their undivided attention. I think court merger will clearly help the issue, because I think that there are many family court judges who would do a very good job handling matrimonial cases, but unfortunately the family court does not have jurisdiction over granting status changes or dealing with equitable distribution. I think statewide court merger, as the Chief Judge has promulgated a plan for, would help.
Judge, earlier we discussed equitable distribution has been in the state now for 17 years. How do you think it's been faring, and do you think it favors one side over the other?
I think on a whole, I would agree with Mr. Gassman. I think it has done a good job on the whole for most families. For the poorer families, of course, it has not done the job it's supposed to. It is, or even the lower middle classes, because it is too costly, first of all. And second of all, for a long time, judges thought because there is equitable distribution, there could no longer was permanent maintenance, and they had veered away from that. And in the middle-class families, in the low-income families, maintenance is more important. Continuing support is more important than equitable distribution, and that was a real problem. But I think we are beginning to address that with changes, case law changes that have changed that.
Steve, what happens in the case, before we talked about people who have assets, what about the couple who wants to get divorced who doesn't have assets? But whatever they have is very important to them. They don't have huge sums, but whatever they have is more important because they need that.
No question about that. And what we're trying to do through this committee and through the system in general is to streamline those cases in particular. They can't afford to go through a long, convoluted process. The little assets they have, they need for themselves and their children.
If they accumulated $100,000, the last people they want to give it to is the lawyers.
Well, and I understand that, Alan, and rightly so. No one's arguing that. These procedures, though, have to be such so that they can accomplish their goal, divide their assets, provide for support, and get divorced without exhausting that fund. And one thing that, for example, that Justice Silverman has done, uncontested divorces in the state were a hodgepodge. There were different procedures in 40-some-odd counties. Now there's one set of forms, one set of procedures, uniform throughout the state.
Will be. It hasn't been passed yet by the administrative board, but we have handed in one set of forms.
Judge, is New York State still a fault state?
New York State is still a fault state.
And what does that mean?
That means you need grounds for divorce unless you have settled your economic conditions and have had an agreement. Then you can get a divorce without proving grounds.
So if my wife and I just say, you know what, we've had it. We've been married all these years. We just, we want to end the relationship.
And have you settled your financial matters?
We haven't settled our financial matters.
Will you be able to? If you're able to settle your financial matters, you can get a divorce without having to call each other names.
Only if you've settled it. And with that, Stephen Gassman, thank you for being on Lawline. Judge Jacqueline Silverman, thank you once more for being on Lawline. And as always, this is Alan Schnorman. Thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111.
This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.